The Fourth Amendment was ratified on December 15, 1791, along with 9 other amendments collectively called the Bill of Rights. The Fourth Amendment, by definition, means people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. That shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, in particular describing the place to be searched and the persons or things to be seized. Basically, the Fourth Amendment had originally enforced the notion that each man's home is his own castle, secure from unreasonable or unknown searches and seizures. Under the Fourth Amendment, people are supposed to be protected from arbitrary arrest, stop and frisk, and unknown surveillance. Although, if police have probable cause and a warrant from a district attorney's office, they are allowed to search your belongings without your consent.
How are you? Sorry. How are you?
What's going on? I'm not going to shake your hand.
Oh, sorry about that.
Why don't you go ahead and leave the door open for me? No, I said open the door. I said open the door.
No.
Open the door now. I don't know what they're hiding from us. I don't know if there's weapons. I want to be sure that I'm not standing in the line of fire. Open the door, sir.
Do not open the door, yo. Don't open the door. Why? I want to see if you got needle. We got needle.
We're not going in.
So open the door. They don't gotta open the door, yo. Listen, they don't got no warrant. Don't open the door. They,
Really? Are you an attorney?
No. Legally, you don't have to open the door.
This kid's trying to talk his friend into not opening this door, and by doing so, he's making this situation worse than it needs to be. I'm giving you one more chance. Open the door now, or you're getting charged with obstructing. Open the door. Open the door.
We got another
Okay,
call
come
that
on.
needs to rush and fine.
All you had to do was open the door. We just wanted to make sure that there wasn't anybody standing right behind it. You know what? I would stop listening to him, because here's the thing. He's the one that's gotten you in handcuffs, because apparently he makes all your decisions for you.
Yo, just be smart. That's all. Just make the
You need to keep your mouth shut, or you're going to get cuffs on you, too. You understand me?
I apologize. I just didn't know, if this was real.
Under the Fourth Amendment, searches and seizures inside a home without a warrant are presumptively unreasonable. In the video you just saw, the officer had no reason to suspect anything illegal was going on inside the house, and therefore had no right to demand the homeowner to open the door for her. However, in this case, it would have been legal for the officer to search the young man's home if he had given consent, the search is incident to a lawful arrest, there is probable cause to search, or if items are in plain view. The big question is, how does one determine probable cause?
Make sure you have your headlights on, okay?
Yeah, definitely.
You play Frisbee golf?
I do, a lot actually. I play out at Heritage.
You
It's
do?
my favorite course, yep.
Okay, I need you to answer me a question. Why is it everybody that plays Frisbee golf smoke weed?
No, it's not everybody, it's just
No,
those
it's
select few.
everybody, man. You can't tell me you've never smoked weed before.
I mean, I'm not gonna tell you one way or another.
See, there you go. How much weed do you have in the car tonight?
I don't.
Nothing at all?
Nothing
on
at
your
all.
person?
Nothing on my
So
person.
if I searched your car, you wouldn't have anything in there at all?
If you searched me right now, I would not have anything on my person.
What about your car?
Nothing in my car.
Okay. All right. You understand you're free to go and everything, but you wouldn't have a problem with me looking through your car?
I actually would, just because I have a disc golf bag doesn't mean that every disc golfer does have weed. So I would
So
actually.
you have weed in the car then, is what you're saying?
No, what I'm saying is I would mind if you searched my car, because you're profiling me based on me being a disc golfer.
No.
Probable cause cannot be determined based on how someone dresses or looks, but rather on evidence that criminal activity is occurring. For example, if someone is pulled over and drugs or paraphernalia is visible, that would be probable cause to issue an arrest or search the vehicle without the owner's consent. Sometimes police abuse probable cause on mere suspicion, but not hard evidence. As demonstrated in the previous video, the officer attempted to search the young man's car based on the assumption Frisbee golfers smoke weed. However, the police officer could not claim probable cause over just a hunch or feeling that the person was guilty. The Fourth Amendment was originally created because the founders of the United States believed that freedom from government intrusion was a natural right, one granted from God, and fundamental to liberty. The founders believed that without it, people would be subject to arbitrary police power and an abusive government. This ideology comes from during the colonial times when British officials had power to enter and search residential homes whenever they wanted to, due to the writs of assistance. The writs of assistance became law under King George of England wanting more control over the colonies. These were legal search warrants that were extremely broad and general in scope. British agents could actually enter someone's property or home with no notice or without any reason. In order to prevent this and fully protect the rights and freedoms of the people of the United States, the Fourth Amendment was created and ratified as part of the Bill of Rights on December 15, 1791.
Since the establishment of the Fourth Amendment, there have been many pivotal Supreme Court cases that specify your rights that are protected by the Fourth Amendment. The first of which was Weeks v. United States in 1914. Police officers in Kansas City, Missouri went to the house of Mr. Fremont Weeks and used his hidden key to enter and search his home. While there, they took papers, letters, books, and other items. They did not have a search warrant. These items were used in court to find Mr. Weeks guilty of sending lottery tickets to the U.S. mail. Mr. Weeks was found guilty in a criminal jury trial in the U.S. District Court for the Western District of Missouri. The guilty verdict was based on the evidence collected from his home. Mr. Weeks then asked the U.S. Supreme Court to review his case. The judgment of the District Court was reversed. The evidence collected during the illegal search was in violation of the Fourth Amendment and was thus inadmissible in the trial. In a criminal investigation, in order for the search to be legal, there must be a probable cause. The probable cause must be used to gain a search warrant. If not, the search will be illegal and the evidence collected as a result of the search cannot be used in court. The Weeks decision was the birth of a new legal doctrine, the exclusionary rule. The next case was Mapp v. Ohio in 1961. The case originated in Cleveland, Ohio, when police officers forced their way into Mapp's house without a proper search warrant. Police believed that Mapp was harboring a suspected bomber and demanded entry. No suspect was found, but police discovered a trunk of obscene pictures in Mapp's basement. Mapp was arrested for possessing the pictures and was convicted in an Ohio court. Mapp argued that her Fourth Amendment rights had been violated by the search and eventually took her appeal to the United States Supreme Court. At the time of the case, unlawfully seized evidence was banned from federal courts but not from state courts. The U.S. Supreme Court ruled in a 5-3 vote in favor of Mapp. The High Court said evidence seized unlawfully, without a search warrant, could not be used in criminal prosecutions in state courts. Following this case was Terry v. Ohio in 1968. This case was the first in a long line of Supreme Court cases that recognized the police practice known as stop and frisk as a legitimate law enforcement tool. Stop and frisk is a stopping and interrogation which may be accompanied by the patting down of outer clothing to make sure the suspect is not armed. A police officer was suspicious of two men who he believed were planning a robbery. He asked their names, patted them down, and discovered pistols on Terry and his companion. Terry was convicted of carrying a concealed weapon. The Supreme Court ruled that, for the protection of an officer, stop and frisk was not a violation of the Fourth Amendment when a police officer's experience tells him that criminal activity may be occurring and that the suspected criminal may be armed and dangerous. The last case is New Jersey v. TLO in 1985. A female student was searched at school and the evidence collected was used by the state in her delinquency trial in juvenile court. TLO are the initials of the 14-year-old girl who was caught smoking in the bathroom at school. Later, in the assistant vice principal's office, she denied smoking. The assistant vice principal demanded her purse and found a pack of cigarettes, rolling papers, marijuana, a pipe, plastic bags, a large amount of money, and a list of other students who owed her money. The evidence was used by the New Jersey Juvenile Court to find her guilty of delinquency. The Supreme Court's findings were that students do have the Fourth Amendment rights at school, but they are balanced with the school's responsibility to maintain a safe and educational environment. The U.S. Supreme Court reversed the New Jersey Supreme Court decision, holding that the school officials can search a student if they have reasonable suspicion. School officials do not need to have probable cause to obtain a search warrant. Reasonable suspicion is a lower standard than the probable cause required for police searches at the public at large.
Resulting from court cases, there have been many rules made for or against the Fourth Amendment. A resultant from the Weeks v. United States case is the exclusionary rule. The ruling is a legal principle in the United States under constitutional law which holds that evidence collected or analyzed in violation of the defendant's constitutional rights is sometimes inadmissible for a criminal prosecution in a court of law. The exclusionary rule is grounded in the Fourth Amendment and is intended to protect citizens from illegal searches and seizures. On October 26, 2001, George W. Bush signed on Congress's USA Patriot Act in response to 9/11. Its title is a 10-letter backronym. USA Patriot stands for Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct Terrorism Act of 2001. There have been some ways to get past the Fourth Amendment. Acting contrary to the venerable principle that ignorance of the law is no excuse, the court ruled that evidence obtained by police during a traffic stop that was not legally justified can be used to prosecute the person if police were reasonably mistaken that the person had violated the law. the Rutherford Institute had asked the U.S. Supreme Court to hold law enforcement officials accountable to knowing and abiding by the rule of the law. Justice Sonia Sotomayor, the court's lone dissenter, warned that the court's ruling means further eroding of the Fourth Amendment's protection of civil liberties in a context where that protection has already been worn down. One form of seizure is asset forfeiture. It is a form of confiscation of assets by the state. It typically applies to the alleged proceeds or instruments of crime. This applies but is not limited to terrorist activities, drug-related crimes, and other criminal and even civil offenses. Some jurisdictions specifically use the term confiscation instead of forfeiture. The purpose of asset forfeiture is to disrupt criminal activity by confiscating assets that potentially could have been beneficial to the individual or organization.